Maybe so, Lordship. I beg to mention item number 19. 19. I believe this matter may be listed after 3 weeks.
You are for
Petitioner,
Mr.
Benison Visual.
Land Council for the petitioner. Praise for listing this matter after 2 weeks.
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Obliged.
This is Lordship.
Hmm.
Lordship, I beg to mention item number 6, Lordship. I pray that this matter may come up on 31st Friday, Lordship.
Friday.
Lordship. On 6.
You are for the state respondent, whether the petitioner is present.
Yes, your turn. No objection.
No objection. Oh. Miss.
Anullah LKR.
Online Kerala Council for the petitioner is present. Miss
Yes, Chang.
Lanet Council for the state respondent. Praise for listing this matter.
On Friday, Lordship, 31st.
Yes. Okay. Why on Friday? This probably is ready for hearing, I think.
Yes, Lordship.
So can it be listed for hearing?
For admission hearing, Lordship. Admission hearing, Lordship.
Admission hearing?
Lordship.
I think the pleadings are completed.
Yes, Lordship, updated.
Then can be listed for hearing only.
Oh, your Lordship, it may become on the admission hearing, Lordship, admission hearing on Friday,
Okay.
Lordship.
Okay. Miss is also present as prayed for by the Land Council for the parties. List is matter on Friday. Okay.
Obliged, Lordship.
Mm.
Lordship, I also like to mention item number 5, Lordship, on behalf of S. Mary, Lordship. And this is matter after 2 weeks, Lordship.
After?
2 weeks, Lordship.
Okay. So probably service is also awaited. Okay. As you are for the petitioner.
Yes, madam.
No objection.
No objection, no.
Okay, Miss Land Council
Keep receiving.
for the petitioner is present. Miss Anya, no, Land Council appearing on behalf of the respondent. Praise for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged, Lordship. My lord, I beg to mention hearing item number 21. My lord,
Yes.
kindly list the matter after 2 weeks.
You are for a petitioner.
Yes, my lord.
Okay. Inform the other respondent also.
Yes, madam.
The respondent number 8 is a private respondent. Have you informed?
No, my lord, here there is no private respondent.
No private respondent number 8.
Is for is accountant in general, my lord.
Okay. Miss
Christine,
Land Council for the petitioner. Praise for listing this matter after
2 weeks, madam.
3 weeks. The prayer is allowed.
Lordship.
Okay. List is after 3 weeks.
Obliged.
Your press. Okay. His presence may also be recorded. Huh? Okay. For the respondent state, huh?
Lordship,
Yes.
I beg to mention item 13. I have taken steps upon the newly implemented respondent number 3.
Yes, yes.
The note-
When did you take?
After 2 weeks, Lordship.
Not yet taken or taken?
It has
Step.
already been taken
When?
yesterday, Lordship.
Oh, that is why on record it was a step not taken, no? Okay.
Your Lordship, I'm appearing for, I have instruction to appear for 1 and 2, Your Lordship.
1 and 2?
No.
Okay. Mr. Santiago, Land Council for the petitioner, submitted he has taken steps upon the newly impleted respondent yesterday only. And praise for listing this matter after
2 weeks, Lordship.
2 weeks. Miss
Livika,
Livika, would appears on behalf of
1 and 2.
the respondent number 1 and 2. And you have praise
only
for,
some time for
praise
instruction.
for some time to obtain instruction. Okay.
Deeply obliged, Lordship. Lordship, I also beg to mention hearing item 18, Lordship. If it can kindly come up after 1 week.
So withdrawal of Wakalatnama,
Yes, Lordship, Lordship. I'll be filing my affidavit, Lordship, within the course of the
Okay.
week.
Mr. Santiago, land counsel for the appellant, praise for
1 week,
1 week time to file necessary affidavit.
my lord.
You are withdrawing from the case
Yes.
for withdrawal of the Wakalatnama stuff. List is matter after a week. Okay,
I'm for respondent number 2,
Okay.
Lordship.
Mr. So he's present. Mr.
Mr. Kachish, Lordship.
Yes, land counsel for the respondent number
2, Lordship.
2 is also present. Okay,
Obliged, Lordship. Much obliged.
May I please, Lordship?
yes,
Lordship, I beg to mention item number 11, Lordship. Here, Lordship, I've been recently appointed as amicus curiae for respondent number 2.
yes, legal aid counsel.
Yes, legally.
Yes.
Lordship, I'm yet to receive the brief, the petition, Lordship.
Okay,
So if sometime may be granted, Lordship, 2 weeks time, Lordship. Because I'm told the IA is for continuation of delay, Lordship.
yes.
So if sometime,
Want to file objection?
Lordship, I have to go to the brief,
Okay.
Lordship, because I have not received the brief till date.
Okay,
Lordship, in that matter, I'll be serving the copy in the course of the day, Lordship.
okay, Mr.
The blue matter on behalf of Asia.
land counsel for appellant
Lordship.
is present. Mr.
And Mosoi.
N.
Mosoi.
Mozoy. Sami said he has recently been appointed as the legal aid counsel to appear on behalf of the private respondent number 2
2, Lordship.
and prays for some time to obtain a copy and to go through the same.
Yes, Lordship.
Okay, stop, Mr. The land counsel for appellant shall furnish a copy of the petition and the application in IA
Lordship,
Hmm?
Lordship.
to the land counsel for the furnish to the land furnish a copy to the land counsel for the respondent number within
In the course of the day, Lordship.
okay during the course of the days. Stop. List is matter after 2 weeks.
Lordship.
Okay.
Obliged, Lordship.
Lordship, I also beg to mention here in item number 20, Lordship.
I
I'm
think
for the
20.
respondent here, Lordship.
Yes.
Lordship, let this matter be listed after 3 weeks, Lordship.
Okay.
No petition, Your Worship.
Okay. Miss
If it's a no.
land counsel for the petitioner is present. Mr.
The blue mark, Lordship.
The blue mark land counsel for the respondent number.
The sole respondent, Lordship.
Okay. Respondent prays for listing this matter after.
Lordship, respondent number 5.
Okay, respondent number 5
Respondent 5.
prays for listing this matter after
3 weeks, Lordship.
3 weeks.
Lordship, there's an interim, Lordship.
Okay, prayer made by the land counsel for the respondent has not been objected to by the land counsel for the petitioner. Stop. Accordingly, the prayer is allowed. List this matter after 3 weeks. Stop. The interim order passed earlier shall continue till the next stage. Okay.
Much obliged.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 7. Item 7, your lordship.
yes,
I am appearing for the sole respondent. I have been instructed that the respondent want to contest the matter, your lordship. And therefore, some time may be granted to us so that we can, I'll get the necessary instruction as well as I'll file our counter affidavit, my lord.
okay. Okay, Miss Anand, huh? So, is present on behalf, present, huh? Land counsel for the petitioner is present, stop. Mr. Angami, land counsel for the respondent number,
Sole respondent, my lord.
okay, respondents. Press for some time to file objection.
Yes, my lord.
Okay, the prayer is allowed. List this matter after
3 weeks, my lord.
3 weeks. Okay.
I'm deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 17. Lordship, kindly list this matter after 4 weeks.
LCR also received. Okay. Miss
Vehicular.
Lana Counsel for the appellant. Praise for listing this matter after 4 weeks. But why after 4 weeks?
Lordship, my senior has some medical emergency, so.
Okay. Prayatullah submits that his senior is out of the station and pray for listing this matter after 4 weeks. So, Miss
Ayala and two.
Lana Counsel for
Respondent one and two.
respondent number 1 and 2 is also present and has no objection. Stop. Accordingly, the prayer is allowed. List this matter after 4 weeks. Okay.
May I please, Your Lordship? Lordship, I
Yes.
beg to mention item number 2, 3, and 4, Your Lordship. Lordship, in item number 3, the respondents have filed their affidavit in opposition, Your Lordship. So kindly grant us
Yes.
time, Your Lordship, to file our affidavit in reply.
You want to file affidavit in reply?
Yes, Lordship.
Okay. 2, 3, and 4. Okay, Mr. Meadow, Lana Counsel for the petitioner prays for some time to submit that he has received the affidavit in opposition and prays for some time to file reply to the affidavit in opposition filed by the respondent number,
Respondent 1.
respondent number 1, staff. The, okay, Mr.
Manchong Konyak, appearing on behalf of Mr. Ejimon.
Respondent number,
One.
you are for 1. Okay, 1, and Miss, you are also appearing for,
On behalf of each one, Lordship.
okay, Jimomi, for respondent number?
2.
Okay. Are present, as prayed for by the Lana Council for the petitioner, list this matter after
4 weeks, Lordship.
4 weeks. Okay.
Lordship, there's an interim, Lordship.
Stop, para. The interim order passed earlier shall continue till the next stage. So, Baraba, the item 4, in the 4 also,
Yes,
you are protected by interim order
yes, Lordship.
in item 4.
Yes, Lordship.
Okay, item 4 also, huh? No, in the item 4, it's AV.
Yes, Lordship.
In item 4, you just write the presence, presence of the counsel for the petitioner, Mr. Meadow, and there you are also in the 4 also you are responding, not in 4. Okay, and her presence, on behalf of Jimomi, So list is after 4 weeks. In the meantime, the interim order pass, I said continue till the next date, huh? Okay,
Most obliged, Your Lordship.
yes,
Lordship, I again beg to mention item number 8, Your Lordship.
Ye-
8B, Your Lordship.
8
Yes, Lordship.
already mentioned, oh, sorry,
I've already.
the application is there,
Yes.
okay. Non-counsel for the petitioner, Mr. Meadow.
Appearing on behalf of I. Chaudhry, Your Lordship.
Hmm?
Appearing on behalf of I. Chaudhry, the leading counsel.
Okay. Meadow appearing on behalf of Mr.
I. Chaudhry.
I. Chaudhary. Non-counsel for the petitioner. Prays for
18 of June. Your Lordship.
submits that the leading counsel, Mr. I. Chaudhary, who is from Gauhati, has some could not appear due to some personal difficulties and prays for adjournment. Okay, the prayer is
Lordship, I have I expressed seeking for adjournment. I have no objection,
okay.
but by order dated 7/5/2024, direction was passed by this court that this honorable court that if they the applicant could not appear before the IO within 10 days,
Hmm.
the at the interim order bail relief given on 16/4 is supposed to be automatically vacated.
Okay.
Now he could not appear except that he
So-
wrote a letter stating that he was having some back problem,
Medical issue.
the medical issue.
We have no idea, but then if that is the condition, then nothing prevent the police to arrest him. Hmm. In that case, unless this court passes some other order. Hmm.
So whether it be more for confirming that the order dated,
Unless we pass some order
yes,
protecting him, then the police can arrest him at any time. Nothing prevents him.
okay. So if a order may be passed indicating
No. Well, what indication?
that
To reaffirm that.
vacating that
We understand,
interim,
but, huh?
vacating that at interim 16 for 2024 lordship. So as not to create confusion.
No, it won't create any confusion unless this court passes any order,
Lordship,
hmm?
lordship,
Any contrary order,
lordship,
nothing prevents
lordship,
the police to arrest him,
lordship,
because if the condition is that,
lordship,
police can act,
lordship. If they-
ask him to produce if he wants,
Lordship,
if he prays for, if he insists for, or if he produce the order also,
lordship,
says it is invalidated,
lordship,
expired.
lordship, then it's lordship.
Okay. What is this, your prayer is for? Listing this matter on
18th of June, your lordship.
18th of June,
Yes, lordship.
okay. And prays for listing this matter on 18/5. Okay. So, Mr.
6, your lordship.
Angami Land Council for Land PP is also present. Staff has prayed, list this matter on 18/5. Okay.
18/6, your lordship.
14/6.
Huh, 18?
6.
You have written 5 only,
Oh, lordship. My
Ah.
apologies, lordship.
18/6, 18/5, see?
Your lordship. My apologies, lordship.
Let him correct. Okay,
Obliged, madam.
I beg to mention item number 16, lordship. Lordship, here,
return service upon the respondent number 2 and 3 also awaited, it appears.
Right.
Hmm.
No objection, my lord.
No objection. Okay, Mr.
Proxy counsel on behalf of Takakichu.
Okay, appear on behalf of Mr.
Takakichu
Takakichi Land Council for the petitioner.
petition.
Mr. Angami PP, sorry, government advocate for the state. Praise for listing this matter after
3 weeks, lordship,
3 weeks. For what?
for receive instruction, lordship. To receive
Okay, praise
instruction.
for some more time to obtain instruction to file affidavit. The prayer is allowed. This matter after 3 weeks. Okay.
Obliged, lordship.
May it please, my lord. Lordship,
Yes.
I beg to mention item number 9 and 10. Lordship, with the other party consent, we pray that the writ petition may be segregated from the contempt petition. Because in contempt petition, again, they are, they
The
also,
the contempt is in this, in the present brief
No,
petition.
lordship.
No, no,
There's
no, no.
no connection with the present case, lordship.
Okay, then,
Because contempt is pertaining to the judicial service.
okay,
So
And this is
direction has
for-
been issued by the court. And then in the writ petition,
Hmm.
lordship this is pertaining to
pension-
payment of pensions.
payment of
Different,
pension.
different, I think.
Different.
Yes,
Not
different.
connected, I think.
Yes,
Not-
that's why it may be segregated, Lordship.
Okay,
And to be heard immediately, Lordship, because the petitioner's husband died on 30/4/2022.
Hmm.
Already 2 years, the department is not processing the pension benefit of the deceased wife, Lordship.
in item
So-
10.
Item number 10. So item number 10, writ petition and contempt petition may be segregated, Lordship.
Okay,
Lordship, in item number 10, the Office of the Accountant General, I am appearing for respondent number 6, the
Hmm.
Accountant General Office, Lordship.
Hmm.
Now, we have written a letter to the government to clarify on to as to whether the age of retirement from service should be 35 or 60. Because as far as state is concerned, Lordship, state have got 2 modes of retirement,
Yes,
Lordship.
yes.
Either by superannuation or by length of service.
Yes.
But whether the judicial service, Lordship, those
It's
employees.
judicial service probably.
It is already implemented
For
and
age only.
it's already implemented and it's under contempt, Lordship.
Hmm.
So they may be segregated and at least if the
So what?
petitioner's pension will be processed. That's all in this writ petition, Lordship.
Okay,
So I pray that it may be segregated, Lordship.
okay.
But please, the lordship, it may be segregated, but more or less it will have an impact because the COP will actually determine this case because whether the petitioner will be entitled by the 60 years or 35 years. So that is the problem.
No,
And it's not
Lordship.
until the COP decides, Your Lordship.
No, Lordship. COP, there is no appeal. There is no appeal and
There is no
it
appeal,
is the
yes.
government themselves who has withdrawn, withdrawn the notification, and now the district court employees is in force since 2017. And that they themselves withdrew it and say that the district court employees rules that is for enforcement. However, in the meantime, this writ petition, because of this, they did not process the pension benefit of the petitioner. That's why we have filed this writ petition.
By
So
which order it was clubbed together?
My
Uh,
order dated 1/3/2024. 1/3/2024.
Okay, Miss
Z. Jimami, Lordship.
Z. Zimomi, Ilan counsel for the petitioner is present. Let us see now. And in the contempt, who is for the respondent?
I'm for the respondent. I have
Okay.
instructions from the AG of the
Okay.
state. Lordship, in this particular case,
Hmm,
this court has directed the AG
hmm,
to appear in this case.
hmm.
So I have instructions that the cabinet is yet to sit over the issue, but it has been fixed on 23rd of June. As I was informed by the AG this morning,
Hmm.
that the cabinet has fixed on to sit on 23rd of June to sit over the issue.
Hmm.
So that is different issue.
Advocate.
Okay, Mr. Huh? Ilan counsel appearing on behalf of the respondent number?
Is for all the respondents.
Okay. Respondents submits date. He has an instruction date. The meeting is, sorry, cabinet sitting is scheduled on 23rd
Yes, Lordship.
to discuss over the present matter.
Lordship.
Okay. And praise for
4 weeks time, Lordship,
listing
because
after 23rd June.
23rd
Okay,
June.
after 23rd June. Okay,
In the meantime, Lordship,
hmm,
the writ petition may be
okay,
segregated.
the prayer is allowed. List this matter after 4 weeks. Stop. The land council for the parties also submits that this contempt case may be segregated from the WPC number 2124. The prayer is allowed. List this matter.
List the
Oh,
writ petition, Lordship.
The prayer is allowed, huh? I don't know why it was then clubbed. By which order you said?
By order dated 1 March,
Hmm.
1st March 2023, 24.
The contempt was fixed for immediate next day disposal, Lordship.
The
That's
operative
why-
part is in the last paragraph 8.
23rd
20
March.
March,
First,
Okay.
first March,
1st
Oh,
March.
1st March.
2024.
Okay, in the last part,
Yes. Paragraph
the
8.
said petition be listed along with, okay, yes. Okay, current council for the party submits that by an order dated 1st March 2023, this contempt petition was directed to be listed along with the WPC number 2124. However, the same is not connected with each other. Hence, the same may be segregated. This contempt petition may be segregated from the said WPC stuff. The prayer is allowed. List this. The prayer is allowed. Huh? This is matter after 4 weeks. Oh, no, after 23rd. After 23rd. Okay. So in the writ petition,
Lordship, if this matter can come after 4 weeks, Lordship.
list writ petition.
Yes, Lordship.
Okay.
Though the
Pardon,
contempt is not
Judge
linked to the
Mohammed.
case, it will have some.
Mr. Jimo Milan, counsel for the petitioner, and Miss, who is for a state?
I'm for the state, Your Lordship, Livika.
Okay, Libika for one, huh? Government advocate for the state respondent, and Mr. I'm
Yeah.
appearing for respondent 4 and 5 on
Oh.
behalf of my senior AG Momi
Okay, yes.
and Solo.
For appear on behalf of AG Momi Lara Council for the respondent number 4 and 5 and Mr.
And Mozart
Mosai,
for respondent number 6.
For respondent Lara Council for the respondent number 6 staff is prayed for by the Lara Council for the parties. List is matter after
4 weeks.
4 weeks. Okay,
Lordship, my name may be reflected, Lordship.
yes, and okay. Mr.
And Mozart.
and Moses name, let the name of Mr. and Moses be reflected in the cause list as the council for the respondent number 6.
Lordship,
Okay.
obligation.
Obliged, Lordship.
For admission, item number 1.
May it please your lordship.
Yes,
Lordship, this matter, this matter is against an order passed against me where I was convicted in an offense under section 354 A11 read with section 12 post under POCSO.
whether appeal lies,
The appeal lies under 374.
374, let us see.
Three 374(1) states that any person convicted in a trial held by a high court, any person convicted in a
374,
374(2)
374 2, okay, any person convicted? Yes,
on a
kindly read.
trial held by a session judge or an additional session judge or in a trial held by any other court in which sentence of imprisonment is more than 7 years,
More than 7 years.
more than 7 years,
Hmm.
and may appeal to the high court.
Okay,
But-
then in your case, conviction is for,
Conviction is for 1 year,
then,
13 months, 13 months.
so this is for appeal lies
Hmm.
if the conviction is for more than 7 years.
Appeal lies if it is passed by the session judge or an additional session judge.
Yes,
It also has to be taken into account because I don't have any other option other than appealing before this honorable high court.
order dated 23/4/2024.
Yes.
I have made publication in the Nagaland newspaper.
You have taken this, you published.
Yes,
Okay,
it's there in the
filing
record.
today or?
I've already filed. Yes,
Already filed.
I've already filed. It's in the record.
Who appears for the respondent there? How many respondents are there?
There are 4 respondents.
Okay, you are
And
for
Respondent number
one,
respondent number 1,
yes.
Yes.
and who is for the other respondent? There are these steps, the public, paper publication is in respect of which respondent?
2, 3, and 4.
2, 3, and 4. No one appears.
No one appears.
Who are these people? Private? No, no.
One is private. Number 2 is private. And 3 and 4 are the BSNL.
BSN are not represented by the standing council, no.
Earlier, they had a studying council,
Hmm?
but earlier,
Hmm.
he had a studying council, but unfortunately, he expired.
Oh, so they did not engage the new council.
Presently, there is no council.
So how it is possible that the big organization could have, must have seen supermarket, it's Nagaland only,
Yes, Nagaland knowledge,
no need to publish in a paper also.
because they are not appearing
Here,
in spite of a number of.
what is the
notice.
claim, by the way? What is this petition about?
Lordship, before I go to the merit, the BSNL and telecommunication, they were under one head, under one department,
BSN
and telecommunication.
okay,
And the present petitioner is a telecommunication. This
what communication?
telecommunication,
Delhi,
TELE,
T,
TE. My Lordship, I come to page number 2, cost title.
department, okay, telecommunication.
Yes. The
Okay,
Joint Controller, Communication of Accounts, Department of Telecommunication. So they were under one head, but they have been bifurcated. And when the petitioner, the respondent number 1, she was under the Department of the Telecommunication. But after the bifurcation, her service was transferred to BSNL. However, the learned district assistant judge Dimago has directed that the telecommunication should pay the pension amount. Those she is working under the BSNL. And in that civil suit, we were also not made a party.
okay, this is for, I think, this is for condonation of delay.
Yeah.
Okay, so what we'll do, we'll pass order then. You have submitted the affidavit.
No, I'm the petitioner, Rashid.
Hmm?
I'm the petitioner
No, affidavit means affidavit, no, for the
of service.
taking steps, huh?
Yes, I have already filed this.
Okay, where have you filed? It is in
It's
the,
in the report.
on record,
It's already given.
it's there.
Yeah, no.
Okay. For Mr. Yangavati, then counsel for the applicant. Mr. Yangavati, then counsel for the applicant submits that he has taken steps upon the respondent number 2, 3, and 4 by a substitute notice. By way of substitute notice by publishing in the newspaper. How many newspaper?
One, Rashid.
Which newspaper?
Nagaland Post.
In the Nagaland Post on,
The same was published on May 3rd.
okay,
Third-
which was
third-
published
third,
on
okay.
May 3rd, no?
Okay.
3 May 2024. So, the copy of the original copy of the paper publication has been produced by filing affidavit as, affidavit, filing affidavit as an evidence of paper publication. And I have perused the same stuff, Mr.
Kampai,
Learned Counsel for the respondent
number 1.
number 1 is present. However, no one appears on behalf of the respondent number 2, 3, and 4. Stop, Para. This is an application under Section 5 of the Indian Limitation Act 1963, praying for condonation of delay of 668 days in filing the connected revision, civil revision petition. So, the ground for delay in filing the connected appeal is has been stated in paragraph. Which paragraph?
No, sir, paragraph 6, 7,
Paragraph 6 and 7 of the petition, application. Stop. You have any objection?
No, my
Okay.
lord.
The petitioner has been able to show a sufficient cause for not filing the connected appeal within a stipulated time stuff. Moreover, the learned counsel for the respondent number 1 has no objection if the delay in filing connected appeal is condoned. The delay of 68 days in filing connected appeal is condoned. So, in view of the above, the delay of 668 days in filing the connected revision, sorry, it was revision, is hereby condoned. Stop. With the above, this applicant stand allowed and disposed of stuff in main. Just a minute. Has it been numbered already?
Yes, sir. 72/2023.
Okay. So this should be in the IA, this order. This cannot be in the revision, the earlier order, it should be in the IA. Okay. Mr. Younger Batila, counsel for the petitioner. And I've also heard Mr. Isnavlan, counsel for the respondent number 1. No one appears on behalf of. So no, don't write that, Not required, stop, huh? So here in the main, you just take fresh steps, revision. Just because it's here only, no need to publish.
In the meantime, Lordship, my AA may be considered.
What,
My IA 73,
what is
praying
that?
for continuation, stay of the degree.
Stay,
Yes,
okay, just a minute.
IA 73.
Para, huh? This is an application under Article 227 of the Constitution of India,
No, Lordship.
Hmm?
IA 73.
I 73. No, no, we'll have to issue notice here.
IA in 73, I am praying for stay.
Stay,
No.
wait, huh? Stay of what?
Stay of the impugned order.
When the impugned order was passed? What is the impugned order?
Order was passed on 3/6/2021 and decree was passed on 7/6/2021.
No. How can that be stayed at this stage?
Lordship, I was not aware. I was not met the party
No,
that,
no, so order was passed in the year 2021.
yes.
How can that be stayed now? What is the order? What is the direction?
Lordship, page 8,
Base?
page 8, next year 8.
Hmm.
Oh, sorry, Lordship, this is decree. Yes. Page 8. It's a short order, Lordship.
Page 8 is?
8, annexure A. May I read, Lordship? It's a
Yeah.
short order. This order, date of order, 3/6/2021, order. This is a suit for declaration filed by the plaintiff praying for a decree for dissolution of marriage between late Enzamo Lota and Srimati Poshoi Lota, and declaring the plaintiff as the legally wedded wife of the deceased Enzamo Lota, and as such entitled to family pension, GIS, GPF, gratuity, leave engagement, and all other consequential benefits. 2. Notice was issued to the defendants on 11/10/2019, and thereafter all defendants entered appearance on 23/3/2021. The parties submitted that negotiation for settlement was going on and paid for time. 3. Subsequently, the plaintiff has filed IA so-and-so, an application under order so-and-so, praying for disposal of the suit on compromise between the plaintiff and the defendant number 1. 4. The plaintiff is heard through VC today due to COVID pandemic and lockdown. Learned counsel for the plaintiff and defendant 1 are present. 5. A copy of the written agreement / compensation compromise deed dated 24th May 2021 is enclosed as Annexure A. 6. Under the above stated facts and circumstances, without going into the merit of the case, the suit is disposed on compromise. The plaintiff is directed to allow the defendant number 1 to apply for the pension benefits of the deceased Enzano Lota. The plaintiff and the defendant number 1 shall equally share all the pending pension benefits of the deceased Enzano Lota, and the monthly pension salary shall also be divided equally between the plaintiff and the defendant 1 every month. The defendant number 2 and 3, BSNL, is directed to deposit the pension benefit in the account of this court. No order as to cost. Registry to issue decree accordingly.
So
as directed.
this was decreed on compromise only.
Yes,
Then how this is revision? Revision lies.
yes.
Let us see the provision of revision.
What I want to say is, I was not made a party. My lordship can see the party. 8.
You are necessary part.
I am not necessary party.
You are related to the petitioner.
No, because the direction was issued to the BSN lordship.
No, just a minute.
However,
You are
I am the joint controller of communication, Department of Telecommunication.
Okay, you are representing Department of Telecommunication.
Yes. As I have stated earlier, lordship, The BSNL was under the Department of Telecommunication.
So this direction is to telecommunication.
This direction was given to the BSNL. However, the BSNL, they have endorsed all the papers to the telecommunication, saying that before the bifurcation, the lead disease, the disease in Samgapata was serving under the telecommunication department.
So he was serving under the telecommunication department.
Yes, before bifurcation.
Order was passed against the BSNL,
Yes,
but the BSNL endorsed it to the telecommunication, saying
Yes.
that he was earlier serving.
yes, yes. Because initially he was appointed under when
And then in the petition, you were never made as a party.
we were never.
Although your department was at that point was in existence.
Yes,
So how he can, the direction is to the BSNL, how
Yes,
the
yes.
BSNL can
yes.
forward it to you?
That is why I'm.
They are not a court to direct you.
The BSNL is saying that since the leg disease was appointed when he was working.
Let them appear, okay, just, in that is this one, in the, just IA, one more sentence, It appears that the respondent number 2, 3, and 4 are not interested, interest to contest. Okay. No, it appears that the respondent number 1, 2, 3, and 4 have no objection in condoning the delay of 668 days, and thereafter that will come in view of the above. Okay. So then since it is already registered, so stay. No, let them appear.
Okay.
So one chance can be given.
Right.
Okay. So in both there, issue notice, hard after hard, already recorded, issue notice upon. Okay. After hard, this is an application in the revision, under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure 1908 for revision of the impugned order dated 3/6/2021 and decree dated 7/6/2021 passed by the learned Principal District and Session Judge Dimapur, Nagaland, in declaratory suit number 01/2019. Staff, para. It is submitted that in the said declaratory suit number 1/2019 filed by, it was filed by respondent number 1,
Yes, Commissioner.
filed by respondent number 1 before the Principal District and Session Judge, comma, the revisionist has not been made as party respondent, and as such the petitioner had no knowledge of passing of the impugned order dated 3/6.
No, no.
Impugned order is
3/6.
3/6/2021, Stop. However, the who forwarded, where is the, have you impugned that forwarding?
No, Lordship,
No.
no.
Okay, where is that order? By order, how, by an order dated? BSN, which order, by which order the BSNL has forwarded to you?
Lordship, I have not enclosed that.
Hmm?
I have not enclosed that.
Have you annexed that one?
No.
Then,
I will file an additional affidavit, Lordship, placing on record.
you have not filed there also? Because there should be, probably, that is one of the impugned order again.
I'll file an additional affidavit, Lordship.
Leave that then. Because by that order only it was forwarded to you,
Yes.
and you are agreed by that,
Well-
that forwarding, because they have no right to forward it. Leave that, huh? Issue notice. Returnable by 4 weeks. Since Mr. Sunsulan accepted notice on behalf, appeared and accepted notice on behalf of the respondent number 1, no formal notice need to be issued against the said respondent. However, the petitioner shall take steps upon the respondent number 2, 3, and 4 by a registered post with ID within a week from today. Stop. List this matter after 4 weeks. Okay. So that will take up thereafter only.
No, no.
Okay. You are supposed to be agreed by that order. Okay.
For orders, item number 15.
May I please, Lordship,
Yes,
as per the direction of this honorable court, my lord, I have taken fresh steps upon respondent number 6 through registered AD.
yes, it is still awaited.
Yes, my lord.
Hmm.
Your lordship, the state respondent has also filed a counter affidavit this morning.
Okay,
However, I have not barraged the whole counter affidavit yet, so it may be come up after 3 weeks.
okay. Miss
Aratsala case, my lord.
Lana counsel for the petitioner is present. And hard Miss Swen, so Lana counsel for the petitioner. She submits that she had just received the counter affidavit filed by the state respondent
Yes, my lord.
and prays for some the same. Stop, huh? The service upon the respondent number 6 is also still, none. As per the office note dated 21/5/2024. The service report, the service upon the respondent number 6 is also still awaited.
My lord, there is an
Service
interim
report, huh?
order.
Service report, huh?
There is an interim, your lordship.
Okay. So in view of the above, list this matter after
3 weeks, my lord.
3 weeks, stop, huh? The interim order passed earlier shall continue till the next date.
Obliged, my lord.
For hearing, item number 22.
Please, Lordship.
Yes,
My lord, in this case, this civil revision, it is on a very limited issue, only on the point of limitation. But before going into that, in this case, there are 3 defendants, 3 respondents. Against respondent number 1 and 2, pleadings are completed. Against respondent number 3,
three respondent,
yes, your Honor, my lord.
just a minute, huh? Yes,
Yes, against respondent,
all are private,
yes, my lord.
okay.
Against respondent number 3,
Hmm.
as per the last occasion, insufficient address
Yes,
was recorded as per the order.
hmm,
But I want to submit before lordship that even in the trial court below, the respondent number 3, against him in the ex parte proceeding
Is he
going
a
on.
necessary party? Is this respondent number 3 a necessary party?
Yes, in some way, but then, my lord, even in the trial court below,
Uh,
proceeding is going on without him. An ex parte proceeding against respondent number
Whether
three.
the decision of the trial court affected the interest of this respondent number
no,
3?
my lord.
No, okay,
No, my lord.
okay.
So my respectful submission is that since respondent number 1 and 2 are represented,
Hmm.
and then since the issue,
How this respondent number 3 is connected otherwise in the case?
yes, in this case, in the trial court below,
Hmm.
there is the plaintiff number 2
Hmm.
has sold off the plot of land which was mortgaged in his name to respondent number 3 without my knowledge. So the civil suit is filed because of that only.
Which was mortgaged.
The plaintiff has taken a loan
Hmm.
from the plaintiff number 1. Plaintiff number 1 is father, plaintiff number 2 is the son. So the defendant number 1, sorry. So the plaintiff has taken a loan from defendant number 1. And as a collateral security, I have mortgaged some portion of my land in defendant number 2 name. And before I could repay back the said amount, without my knowledge, the respondent defendant number 2 has sold off the land to defendant number 3.
He is a
So-
third party interest.
Yes, without my knowledge.
So your grievance is against defendant number 2.
Yes, in the civil suit. But then in this
But then,
civil revision,
but the presently the land is under possession of respondent number 3.
yes,
He is a
it has been
necessary
mediated in his
party.
name. But then so far as this civil revision is concerned, my lord,
Hmm.
we are not on that.
Okay,
During the pendency of this civil suit, the principal plaintiff expired in on 30th of January 2020.
okay.
And then after that, the COVID period started.
Hmm.
And I have filed a substitution petition to substitute the legal heir of the plaintiff,
Hmm.
which was well within the limitation period.
Hmm.
But then the consideration by the Honorable Civil Judge Senior Division. The issue is that only on the civil
So
revision.
this,
My lord, if you
this is for
civil revision,
civil revision.
yes,
Revision of which, what order?
yes, my lord. The impugned order is at page 44. The relevant part starts from page 47, my lord. If I may read, my lord, the impugned order.
Just see, this is. Okay, this is order.
Yes,
44 is the order.
yes. And then the relevant part starts from page 47, the order of
Page
the impugned,
47.
which is under challenge.
Okay,
May I read, my lord?
yes, please.
This order proposes to dispose IA civil number 86 of 22, moved by the plaintiff petitioner under order 22 rule 3 of CPC through his learned counsel, praying for substitution of the deceased plaintiff by the legal representative, that is wife of the deceased plaintiff, Srimati Narol Obet, who may further be allowed to be represented by previous attorney holder petitioner Tito Shohai. I have heard the learned counsels at length and have perused the materials placed on record along with the application. Learned counsel for the plaintiff petitioner submits before this honorable court that the petitioner is the special power of attorney holder duly authorized by Shri Zat Obet as the principal, being an octogenarian, was unable to move freely. Hence, the petitioner as the plaintiff has filed the instant civil suit against the defendant opposite parties. It is submitted that the principal during the pendency of the suit had expired on 31/01/2020. In support of his submission, learned counsel relied upon the death certificate dated 26/2/2020. It is submitted that after the demise of the principal, let Zat Obet, his wife Srimati Narola Obet, and son Sri Salu Obet executed a fresh special power of attorney nominating, empowering, and authorizing the present petitioner plaintiff to represent them. In support of his submission, learned counsel relied upon the special power of attorney document dated 27/02/2021. It is also submitted that Srimati Narola Obet, wife of the deceased plaintiff, be allowed to be represented by the petitioner attorney holder. In view of the above, it is prayed by the learned counsel for the plaintiff petitioner that the instant IA be allowed in the interest of justice. Per contra, learned counsel for the defendant opposite party number 1 and 2 vehemently objected and submits that a special power of attorney placed on record in this instant application, nominating, appointing, authorizing the petitioner plaintiff as attorney holder by the wife and son executants of the deceased principal dated 27/2/2021 is not tenable, as the defendant opposite party number 1 had already been authorized to represent the principal, let that obey provide authorization letter dated 16/8/2013 in respect of the plot of land situated at Parampukri village bearing pata number 23, duck number 98-101 Moza Dimapur, measuring an area of 26 biga, 0 kata 0 lesser. It is therefore submitted that it would cause grave injustice to defendant opposite party number 1 and 2 if the instant application is allowed. Hence, this application moved by the purported attorney holder petitioner be dismissed. Reasons and decisions thereon. After hearing the parties, it appears that the period of limitation prescribed by law has to be looked into. For better understanding, relevant sections under the Limitation Act 1963 are reproduced. So this is the limitation period chart. The law is clear on the point that by virtue of Section 3 of the Limitation Act 1963, every suit application filed after the expiry of the limitation period is liable to be dismissed, even if limitation is not set up as a defense. It is also made clear that the period of limitation to have the legal representative of deceased made a party to the suit under the Code of Civil Procedure is 90 days from the date of death of the party concerned. These are the positions of law governing the period of limitation in the case at hand. Now coming to the case, upon hearing the parties and perusal of the materials placed in report, it is apparent that the principal plaintiff Sri Zat Obed had expired on 30/01/2020, and this fact is not disputed. It is also apparent from the report that this instant application for substitution of the deceased plaintiff by the legal representative has been filed on 23/02/2022. Hence, it is seen that after 753 days from the date of demise of the principal plaintiff, this instant application has been moved, which is way beyond the period of limitation prescribed by law, which is 90 days. This being the case, the instant application is dismissed, being barred by limitation. In the result, IA 86/22 is disposed of on contest. Look, in this case, the Honorable Apex Court has excluded the period of limitation from 15th March 2020 to 28th February 2022. This period has been excluded from the period of limitation.
Excluded period is
15/03/2020
20,
15/03/2020 to 28/02/2022.
22.
Yes, my lord.
Okay.
Because
so
of COVID, this period has been excluded.
With how many days that consist?
So if from I have filed after 46 days only. So I'm well within limitation.
No, the exclusion period, how many days it is? Total? From 15/3/2022 to 2020 to 28/2/2022.
It is nearly coming to 2 years, my lord.
Okay. You have not calculated the days. How many
So as
total
per
days?
this
Because
impugned order
the
is
delay is
753 days.
753 days.
Yes, but then the trial court below did
Ah.
not take into consideration the
How many, according to
excluded
you,
period.
is to be minus from this 753 days?
Yes, my lord, I am not barred by limitation. I am well within time. But then the trial court below did,
As per their calculation,
Yes.
753 days.
yes.
So according to you, how many days? So, not
The-
753.
No, not 753. I'm well within 90 days. I have annexed the apex court order also, my lord. It is clear from that. That will be at page 59.
So on what basis this, the learned trial court has calculated 753 days?
The trial court below
Ah.
did not take into consideration the excluded period of limitation passed
What
by
is
the
the
honorable
total
apex court.
what is the total days of exclusion period?
That will run from 15/3/2020 to 28/2/2022.
So how many days that consist?
If I
We
may
calculated
quickly
now.
calculate.
20,
As per this
21.
order, 753 days, it says
22, 7?
53 days.
The total days exclusion period also 753 days.
No, my lord, from the date of filing, as per the honorable court's order. But then I am well within the limitation period.
So that is why I'm saying.
Yes,
So
I have
total
filed,
after
yes,
how many days you have filed?
I have filed on the substitution petition has been filed on 23/02/2022.
So the earlier petitioner expired on
30/01/2020. So from 30/01/2020 to 15/03/2020, it is only 46 days.
30/01/2022.
15/03/2020,
This is only 42
only
days,
46 days.
46 days.
Yes, so I'm well within the limitation period. And from 15/03/2020 to 28/2/2022, that is excluded period.
Okay, you have filed this petition on
I
28
filed on 23/02/2022. So I'm very much well within the limitation period.
22.
Yes, my lord. I filed a substitution petition on 23/02/2022.
So exclusion period is 15/3/2022, 28/2/2022.
Yes, my lord.
Exclusion
Excluded
period.
period.
So you filed this within this exclusion period.
Yes, my lord.
And the earlier period only 46.
Only 46 days.
46 days.
Yes.
And then what is the time period for filing the?
90 days, 90 days,
90
my lord.
days. So this was within.
Within
46 days.
limitation. But then the trial court below did not take into
Okay,
consideration the,
so, yes.
yes,
ah,
that is the only issue.
May it please your lordship.
Yes, please.
Lordship, the question of whether my learned friend had approached the trial court within the permissible period under the limitation is not disputed, lordship. I
Okay.
concede to what my learned friend has submitted,
Okay.
but lordship,
Hmm.
if I may, at the time when this IA was filed for impleading of the LRs, as the plaintiff had deceased, my learned friend had approached the court with an application for impleading the LRs, but there was no application for condonation. And therefore, the learned trial court had, lordship, rightly or wrongly, passed an order to the effect that this is not within the period of limitation, and therefore it was dismissed, lordship.
Okay.
And if I may,
Where have you annexed the Supreme Court's order? You annexed?
Yes, yes, my lord.
Let us see,
That is at page 59, my lord.
page 59.
Yes, my lord. Annexure 13.
Okay, where the relevant?
Relevant
portion?
part is at page 61, my lord. Para 5.1.
Page 61,
Page 61, my lord.
para
5.1.
5.1.
Yes, my lord. May I read, my lord?
Yes, the order.
The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 5/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings, my lord.
Okay. So what is you are for? Same.
lordship, yes, we are, she is my associate,
Okay.
we are for
Okay.
respondent number 1 and 2.
Okay, so I think
My lord,
he's well within the time.
Lordship,
My lord, with all due respect to the submission made by the learned counsel for the defense,
Yes.
since I was within limitation,
Hmm.
I did
No,
not file
not
any
required to
condemnation.
file.
That was not
required.
required.
Hmm.
Since I'm within time.
I think,
lordship, it is not my case that the court, it is not my contention that the
Right.
court ought to, in this particular case,
Right,
take a
right.
hyper-technical view.
Hmm.
But lordship, in this particular case, it is well settled law that the trial court is presumed to know the law, the status of law and all, the position of law. However, even in such a backdrop, that does it, the learned counsel and the petitioner is not bereft of his duty to apprise the court of the settled position of law, lordship. And
could
Right
have,
or wrong?
one small paragraph could have included according to you. Hmm.
according to me,
Yes.
lordship, even in the cause title,
Hmm.
record speaks for itself,
Yes,
there
because-
is not a whisper of condoning the delay.
Yeah, not condoning, but then within time, would have said within time, file within time, no? So, but
Yes,
then-
yes, lordship. And therefore, lordship, the my learned friend's petition at page number lordship, if I can take your lordship's attention to page number 50. Lordship, this is the impugned order. So by this, this is the conclusion, and here it is apparent that this being the case, the instant application is dismissed, being barred by limitation.
Where,
It has been
where are you
dismissed, Lord.
reading? Where
Page
are-
number 50 of the review
Impugned order,
petition.
Page 50.
Yes, Lord. Page
Okay.
number 50.
Okay, this is, yes, this is.
Yes,
the-
Lordship.
Okay.
And Lordship, yes. And to this
This is an
effect, a
application.
review application was not filed. This application for impleading of LRs was dismissed, Lordship, rightly or wrongly, as stated earlier.
Hmm.
And therefore, Lordship, there is no longer a plaintiff in the case, and therefore the suit abates.
No longer?
A plaintiff, Lordship.
Okay.
No LR has been impleaded. There is no LR, and therefore the case comes to a natural death. That is my contention, Lordship. I'll satisfy my Lord with case laws also, as and when my learned friend is complete. Lordship, after this was passed, the petitioner at page 51, if my Lord may turn to page 51, had filed an application. This was filed under section 5 for condoning the delay. Page number 53 of the cost title is clear on this. An application under section 5 of the limitation.
This is filed by whom?
This was filed by the petitioner.
Applicant.
Yes,
The
yes.
present
Plaintiff.
petitioner.
Yes.
Yes, my Lord. Since
So this is after the,
After the dismissal of that item.
okay,
Yes.
after the
yes,
dismissal.
Lordship. Yes, Lord.
Okay, this was also dismissed then.
This was never admitted.
Never admitted.
And-
And it was
and-
withdrawn.
Uh,
Yes.
What order, any order passed?
Yes, Lordship.
What is the
This-
order?
The
The
is
order, yes, please.
Page 58, my lord.
Page
58.
58.
Page 58.
Okay,
The relevant part, my lord. Learned
Yes.
counsel for the plaintiff submits before this honorable court that she may be given some time to take necessary steps as regards order dated 4/8/2023, passed by its honorable court in IA number 86 of 22 before the appropriate forum. So we were directed, given time to file appropriate, take appropriate steps before the appropriate forum, my lord.
okay.
So and after
Forum
that,
means, thereafter, what did you do?
we have filed this civil revision.
This, so the case is still pending before?
Yes, my lord.
Okay. If fair enough, your submission also?
Lordship, yes, I would have
Any
some
other-
points, yes, I'd like to
That is
argue,
for what?
if at all my learned friend is complete.
Yes,
Okay.
that is my submission, my lord.
Okay, okay.
Lordship, here, coming back to the facts of the case,
Hmm.
the application for implement
Take-
of the
take it.
LR was disallowed, and therefore, in such a backdrop, when the application was disallowed, there is no plaintiff in this case, and the case has abated, Lordship. To that effect, Lordship may kindly peruse this decision of the Honorable Supreme Court.
No, the miscellaneous application, this is still pending, I think.
Lordship, this miscellaneous application was never admitted, Lordship. It is an application filed under section 5, Lordship, in isolation, Lordship. It is not an application for implement read with section 5 of the limitation. It is just an application under section 5 for reviving the case, Lordship,
Okay.
for condoning the delay. So when the previous IA was dismissed, Lordship,
Hmm.
no review application was filed, and therefore, theoretically, I would say the court becomes functus officio, and therefore, in the absence of an application for review for correcting that particular order whereby the LRs were not allowed to be impleaded, that becomes the order of the day, Lordship. And in this particular decision, if my lord may kindly turn to page number 18, para 5, Lordship, this is a decision of the Honorable Supreme Court, Lordship. Here it says at the relevant paragraph is para 5, however, the relevant portion is at page 19, Lordship. Page 19,
Yeah.
para 5. I'll just read from the beginning here, page 19. A site of abatement, this is the relevant portion, Lordship. A site of abatement was prevented by sufficient cause from continuing the appeal. The court may decline to set aside the abatement. Then the net result would be that the appeal would stand disposed as having abated. Lordship, this is most relevant for my case. It may be mentioned that no specific order for abatement of proceedings under one or other provisions of the Order 22 is envisaged. The abatement takes place on its own force by passage of time. Lordship, so the position of law is clear on this, that no speaking order in black and white need be passed stating that the suit has abated, Lordship. And also, if my lord may be kind enough to refer to the CPC for one provision, Lordship. Order 22, Rule 9. Has my Lordship found?
Effect of abatement.
Yes, Lordship. So my previous point was that there is no LR in this case. There is no plaintiff.
LR
Therefore,
means?
the suit has, my lord, legal representatives.
Yes.
Since there is no longer a plaintiff, the suit has abated. And continuing from that point, Lordship, what the law envisages under Order 22, Rule 9, Clause 2, Lordship, is that the plaintiff or the person claiming to be the legal representatives of a deceased plaintiff or the assignee or the receiver of in the case of an insolvent plaintiff may apply for an order to set aside the abatement or dismissal. And if it is proved that he was prevented by any sufficient cause from continuing the suit, the court shall set aside the abatement or dismissal upon such terms as to the cost or otherwise as it thinks fit. Lordship, this provision states that when the suit has abated, an application ought to be filed under this particular provision, Order 22, Rule 9, praying that the abatement be set aside, Lordship. The final argument, Lordship, I'll just be very brief and concise, Lordship. It's another decision. I'll just rely on two decisions of the Honorable Supreme Court, my Lord. Lordship, from the cost title of this civil revision petition, it is apparent that my learned friend has invoked the provision of revision and also 227 of the Constitution. Lordship, the relevant paragraph I wish to rely on is para 22.8 at page 701, Lordship. Lordship, para 22.
Yes.
I may be allowed to read this. Now, what remains is the question whether the High Court should have entertained the petition under 227 of the Constitution when party had two other alternative remedies. Though no hurdle can be put
Just a minute.
against. Lordship.
Now, what remains is the question whether the, High Court should have entertained the, when the,
Lordship,
when party
when
had
party
not
had
to-
two other alternative remedies.
Hmm.
Though no hurdle can be put against the exercise of the constitutional power of the High Court, it is a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of such remedies, one of or the other, before he resorts to a constitutional remedy. Learned single judge need not have entertained the revision petition at all, and the party affected by the interim ex-party order should have been directed to resort to one of the other remedies. Lordship, this particular case also is somewhat similar to this case where other statutory provisions were there, but the petitioner impulsively rather chose to invoke 227.
Now, where is the case? Because they have already filed,
Lordship.
which has been dismissed.
Lordship. So my contention is that a review petition ought to have been filed in that regard, or the application under Section 5
Review
cannot
could have-
survive in
review could have,
isolation.
But then even after hearing only,
Yes, Lordship.
it was dismissed.
Lordship.
Review probably
Yes, Lordship.
might have expected that the review will not, it will not help them. Review could have been, of course.
Lordship. They could
The
also have
alternate.
very well have preferred an application under Order 22 Rule 9. That is for
At the time of filing
Lordship.
before the learned trial court, this order of the Honorable Supreme Court was also presented.
No, my lord.
It was not presented.
Yes. Because we are well within limitation.
Then your learned friend has rightly submitted that review could have filed annexing those Supreme Court's order. Could have been.
Yes, I think it might have been verbally submitted, but then as per the petition, it has not been annexed. But then since I'm well within limitation. And then
No,
since,
because the learned trial court at that point in time probably had not come across this order. Supreme Court order. So that is why it was duty on your part to show that because of this, I did not file the condemnation petition. And because of this, I'm within time, well within time. So this was not apprised before the line of trial court. Trial court would automatically pass that order,
Yes, my lord.
you know. Barring this
Yes,
Supreme
yes.
Court judgment, the line of trial court was right, isn't it?
Yes, my lord.
Could have presented.
Yes.
And then by way of review also,
Yes.
even after dismissal.
In the petition,
He
it has
was
not been
right,
annexed, but
he's
then
right.
verbally, I think it has been.
But then for
admitted.
end of justice, probably.
Yes.
Okay, I'll pass order, huh?
Yes, Lord.
Okay, hard, Mr.
Vinokachumi.
Land Council for that. This is a revision.
Yes, my lord.
No, civil.
Civil
okay.
revision. ma'am.
Okay. For the petitioner. Also hard, Mr. Iralo. Yeah, how many respond, you have 4 respondent number?
1 and 2, Lordship.
1 and 2.
Yes, my lord.
No one appears on behalf of the respondent number 3. Stop. Okay. Para. No, not now. I'll take some. This is an application under section 115 of Civil Procedure Code 1908. Read with Article 227 of the Constitution of India. Selling the impugned order dated 4/8/2023, passed by the learned Court of Civil Judge Senior Division, Dimapur, Nagaland, in IA, within bracket civil, number 86/2022, arising in CS number 12/19 2019. Stop. The case of the petitioner is that your power of attorney holder.
Yes, my lord.
Okay. So initially the suit was filed by the deceased.
True power of attorney holder.
Hmm?
True power of attorney holder.
True
The
power.
principal plaintiff, the present petitioner.
Where
is the
have
power
you
of-
stated?
Yes. Para 2.
Okay, the petitioner is the power of attorney holder of the plaintiff in civil suit number 12/2019, 12/19, 12/19. Stop. The suit was for the suit was for declaration of rights, title, interest, recovery, and restoration of the possession of the suit land measuring an area of 2,983 square meter, 2,983 square meter. Perpetual and other consequential relief in favor of the plaintiff. Stop. So during the pendency, who died?
Principal plaintiff died.
Plaintiff, the power
The
of
husband,
attorney holder.
No, the principal plaintiff.
Okay.
Now the wife has appointed the present petitioner,
So
who is a power of attorney holder,
you are the wife of
the husband. I'm the wife now.
wife. So the power of attorney was in favor of the petitioner wife.
The power of attorney was in favor of the present petitioner. The husband has given his power of attorney to the
The
present
husband
petitioner.
died.
Husband died.
Okay. Hmm. The said suit was admitted on 10/6/2019. Stop, huh? However, during the pendency of the said suit, the principal petitioner,
Principal plaintiff.
principal plaintiff, the husband of the husband of the plaintiff petitioner, no, the plaintiff petitioner herein expired
Right.
on
30/01/2020.
30/01/2020.
Yes, my lord.
20, stop, huh? Then what happened? So
Now the wife
Hmm.
has appointed a new power of attorney holder.
often she is the legal heir,
Yes,
and also she is
she is the wife.
wife. Okay. And any other authorization
Yes, my lord.
like
That is at page 38, annex 8.
what is that?
The wife has appointed the present petitioner to be his power of attorney
So
holder.
this was earlier executed. This was
After
earlier to file plaint. To file,
the
this is
earlier power
to
of
file
attorney.
suit. This is to file suit.
Yes, my lord.
This was earlier only.
The earlier one is
After
the-
date, after
after
date,
the
whether
date.
succession certificate, etc., any
Yes, yes.
Hmm.
Annex 8, page 38. The
38.
power of attorney. Yes,
Power of attorney is executed by,
the wife authorizing the present petitioner.
okay, present petitioner is again different.
Same person.
Okay,
Earlier, the husband also appointed the same person to represent him.
okay, okay.
Now the wife
Okay,
has appointed the same petitioner to
right,
represent
huh.
him.
After the date of the principal plaintiff, the wife of the principal plaintiff, Srimati, who?
Narola Obet.
Narola
Obet.
Obed,
Page 39. That is at page 39, my lord.
who is the legal heir and successor of the principal petitioner, plaintiff, by way of executing a special power of attorney, has authorized the present petitioner
Yes.
to represent and file what? Substitute? File what?
To represent in all the pending cases that
Okay, to
can be
represent
seen in the
in all
power
the
of attorney.
pending cases. Where it is?
Page 38. Second para, my lord.
Hmm?
Page 38, second para.
To represent in any court of law or any other authorities in all matters and things relating to civil suit. Any matter, things relating to civil suit, case number 08/2015, 12/2019 and CR 31, 31, 18. 31 stroke 18, huh? Stop. Okay, the power of attorney holder is Tito Sohe.
Tito Shohan.
Okay. Stop, huh? And accordingly, he filed a
IA 86.
IA,
20.
and accordingly, the petitioner filed IA at page
Page 40, madam.
40.
40. Annex 09.
Okay. File. What is this? IA civil number 85
86.
86, 86. IA civil number has stroke 86 stroke 22 arising out of CS number 12 stroke 19. Before the Land and Civil Judge Senior Division, Dimapur, Nagaland. This is for what?
Substituting.
For then and under order 22 rule 3 of the CPC for substitution of the plaintiff by a legal representative.
Yes,
The plaintiff deceased, huh? So substitution of the deceased plaintiff by legal representatives. Stop, huh? Okay. Stop, huh? Para. And thereafter this disposal.
Yes, the
Dismiss.
impugned
Okay.
order.
Impugned order is at? Okay, 44.
Page 44. Relevant part is page 47. Page 47.
Okay. However, the said IA civil number 86 has been dismissed on a ground of dismissed being barred by limitation. On the ground of being barred by limitation, huh? Stop. Stop. Para. The Land Council for the petitioner submits no. Okay. Thereafter, so while filing this is your annexure 11. This is IS civil number. This petition letter on which was
It
submitted.
has not been admitted. We have filed, but then we have.
Here you have apprised the order of the Supreme Court also.
Yes. But then
Okay.
that was not moved, and then we were directed to take
Okay.
necessary steps.
Thereafter, the petitioner has filed an application under section 5 of the Indian Limitation Act 1963, praying for condonation of delay of 753 days.
Yes, madam.
In filing the substitution petition. Before the learned civil judge, senior division, Dimapur, Nagaland. Apprising the trial court. That there is no delay. Have you apprised here?
Yes, my lord.
Okay.
And then in that
The
petition,
learned trial court, that in view of the order passed by the learned, passed by the Honorable Supreme Court in what case?
that can be seen in page 59, my lord.
Hmm.
2022 3 SCC 117.
In cognizance for extension of limitation in RA, huh? What is the case number? Which one? Reported in
2022 3 SCC 117.
2000, no, this is, okay. It was a suo moto.
Yes, my lord.
Okay. In Honorable Supreme Court, in suo moto case, in cognizance for extension of limitation, comma, in RE, in re, this all in capital, reported in 2022 3 SCC 117. The applicant was well within the time. And have you stated there that there was no delay?
Yes,
Where?
but then that application was not admitted.
Okay,
And
no,
then
no,
we were
no,
directed
no,
to
no,
take
your
necessary
statement,
steps.
your statement. Where have you stated that there was no delay? Stop. However, the said petition for condonation of delay was never, has never been admitted. Was not admitted, huh? How? Not admitted. Where is the order passed in that?
And 14/9/2023.
No, where?
Page 58, my lord. Page 58. Page 58, Annex 012.
But the said petition was not admitted by the learned trial court. However, by an order dated 14/9/2023, the learned trial court what is this order dated 4/8/2023?
That is the impugned order, my lord.
Okay,
The Honorable Tribal,
The given liberty, the Northern Trial Court by an order dated 14/9/2023 has given liberty to the petitioner to approach before the appropriate forum against the order dated, against the impugned order dated 4/8/2023, passed in IA number 86/2022. Stop, huh? Para, being aggrieved, being highly aggrieved by the impugned order dated 4/8/2023 and being and the so here it was not admitted, it was only your prayer was recorded.
yes, we
So
were
it
given time to take.
Did not say that they are not, the land court below is not admitting, did not say anything.
No,
Okay,
the trial court below was pleased
Okay.
enough to give us time to take necessary steps.
okay, being aggrieved, highly aggrieved by order dated 4/8/2023 and the not admitted, how do you know that it was not admitted? How you know, came to know that this was not admitted?
We filed, but then it was not admitted, and then we were directed to take necessary steps, my lord.
It was not registered again.
Yes, my lord. And then on the next date, on 14, we were directed to take necessary steps. Because
So by
since,
passing this order,
yes,
okay. And non-admission of the IA filed for condonation of delay. The petitioner is before this court by way of filing this revision petition. Stop. It is it is submitted that the principal plaintiff expired. The Lani counsel for the petitioner submits that the principal plaintiff expired on
30/01/2020.
30/01/2020.
20.
Thereafter, when the 20 stop, Thereafter, the COVID pandemic, started from 15/3/2020.
Around that time, but then the
Ah.
limitation
Okay.
covers from 15/3.
So no, COVID pandemic, the ban call started with effect from 23/3/2020. And it continued till 28/2/2022. Stop, In this regard, comma, the Honorable Supreme Court, that's a para, huh? So, no, no, after stop, huh? In this regard, the Honorable Supreme Court took so much to cognizance of the difficulties faced by the litigants in filing petition, stroke applications, stroke suits, stroke appeals, stroke all other quasi proceeding within the period of limitations prescribed under the general law of limitation or under any special laws within bracket both central and stroke or straight bracket close due to the outbreak of the COVID-19 pandemic as when this order was passed.
My lord, the date is not mentioned in this order.
Passed an order whereby at passed an order in the case name would be cognizance for extension of limitation in RE, huh? Reported in 2022 3 SEC 117 whereby at para 5.1 where is the first? This is order that is restored. First order was, I think it was
Yes,
passed earlier.
many orders has been passed, my lord.
Hmm?
And then this is the last
I
order.
mean, this is last order,
Yes,
huh?
yes.
Order on, okay, order, huh? The relevant portion is relevant portion at para 5.1 5.1 is reproduced here in below, stop, huh? Here in below. Then this 5.1 I've marked, huh? You write all the order dated 5.1, huh? The order dated 23/3/2020 within bracket, huh? Cognizance for extension of limitation in within bracket 2020 bracket close 19 SCC 10. Huh? Leave that. 23/3/2020 is restored. And in continuation of the subsequent order dated 8/3/2021, comma, 27/4/2021, and 23/9/2021, comma, it is directed that the period from 15/3/2020 till 28/2/2020 shall stand extended for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. It is further made clear that consequently, the balance period of limitation remaining is as on 3/10/2021, if any, shall become available with effect from 1/3/2022. Stop. Para. In view of the above order passed by the Honorable Apex Court, in cognizance for extension of limitation in RE, comma, there was no delay. Sorry, the applicant stroke plaintiff stroke petitioner was well within time in filing the said IA for IA number. What is the IA? number?
86.
Hmm?
86
86
of 2022.
of
22.
2022 for substitution of the principal plaintiff by his legal heir, and there was no delay in filing the same, stop. However, without considering the above direction of the Honorable Supreme Court in in cognizance for extension of limitation in within bracket supra bracket close, the learned civil judge, senior division, Dimapur, Nagaland, has dismissed application, dismissed said IA on the ground of being barred by limitation. Stop. The Learned Counsel for the petitioner further submits that after dismissal of the said IA number 36 of 2022, no?
86 of 2022.
Oh, sorry, 86 of
22.
2022. The petitioner has tried to convince the Learned Trial Court by filing another IA for condonation of delay and apprising the direction of the Honorable Supreme Court passed in cognizance for extension of limitation in RE supra. However, the same has also been rejected by not accepting the petition itself. Stop. And pray for direction, pray for setting aside and quashing of the impugned order dated for 8/2023 and for direction to allow the petitioner to file substitute petition. No, yes, okay. Stop. Okay. Para. On the other hand, the land council for the respondent file you have filed. Have you filed the counter?
Lordship, I have.
You have?
Yes,
no?
I.
Yes. Okay. But, by filing affidavit in opposition, the land council for the respondent number 1 and 2, by filing affidavit in opposition, has submitted that your main submission is,
Lordship, that the moment the impugned order was passed, the suit had abated.
okay, the moment the impugned order was passed, comma, the suit was abated.
Lordship.
Have you, whether that statement you have,
Yes, Lordship, it is at para 8.
okay. Okay, the suit was abated, huh?
Lordship.
And then, what
Lordship,
else?
and that when law prescribes procedure, that should be followed. That is part of my argument, Lordship. That the
Okay, this is provided under? This provision is provided
Lordship,
under?
when suit abates, it should application under Order 22 Rule 9 should be filed. That is also a part of my argument, Lordship.
Hmm.
Order 22 Rule 9, Lordship.
And under the circumstances, and under the situation, huh? The Order 22, Rule 9 of Civil Procedure Code will proceed.
An application should be filed under Order 22.
Okay, under circumstances.
Yes, Lordship, as opposed to
Okay,
this under 227.
okay. Under the circumstances, the petitioner has an option to file application under section, under Order 22, Rule 9 of Civil Procedure Code. Okay.
Lordship, and my final argument in this regard is that
Hmm.
the application, the application, more particularly 89 of, my apologies.
The land
86
council
of
for the
22
respondent further submits that
Yes.
the application,
under IA 86 of 22.
hmm,
Yes,
the application under,
yes,
submit that the application under, application filed being IA
yes.
number 86 of 2022
Was only under Order 22 Rule 3.
was only under order, just a minute.
Yes, Lordship. In the cost list at page 41, Lordship, the
Yes,
relevant
just a minute.
provision is reproduced.
Was only under,
That's page 41, my lord.
order,
22.
order 22, rule 3
Yes,
of the CPC
yes, yes,
for substitution of the deceased.
Lordship. And
Plaintiff.
it was only based on this that the learned civil court
Substitution of the
passed this
deceased plaintiff by the legal representative,
Yes,
that is the wife of the deceased plaintiff.
Yes, Lordship. Where there is no whisper of
However,
combination of
however, there was no whisper in the entire application for condonation of delay,
Lordship,
for condonation of
Yes, yes.
delay
And the
in
learned-
filing the
yes.
said application.
And based on that, only the civil court
Stop.
had passed an order.
And based on that petition, the impugned order was passed by the landed CJM, Chief Judicial Magistrate, sorry,
Lordship,
landed civil
civil
judge,
judge,
senior division,
Senior division. Yes, Lordship. And Lordship,
passed the impugned order by the landed senior division, civil judge, senior division, huh? Dimapur.
Lordship, therefore, at this juncture, the
Okay,
party
stop.
may be directed to approach the appropriate form under relevant appropriate provisions of law. Lordship,
Therefore,
that is
it is
my
further
submission.
submitted that the party may be directed to file appropriate application before the before the civil judge,
Appropriate forum.
before the appropriate forum.
Lordship,
Okay,
Lordship.
okay. That's all, huh?
Lordship,
Okay.
that's all. Thank you.
Art board. The land council for the parties. Huh? So the rest of the order I'll pass. Okay. So we'll complete it in the. Okay. Any other matter? Okay.
Oblige, my lord.
Yes.
Oblige, Lordship.
Itu mulutnya sedek. Saya cuma panggil bola.